That.
Mr. Chairman.
Honourable Simon Power.
Mr. Chairman, just wanted to respond very briefly to some comments that were made by Stuart Nash in respect of suppression. The bill will see defendants able to apply for name suppression, but only on the following grounds: to prevent extreme hardship to them and or persons connected with them, and on the ground where publication would cast suspicion on other people that may result in undue hardship. That's in clause 204. To address this concern with the public, that the public have, rightly in my view, about supposed well-known people being given preferential treatment, the legislation provides there will be no presumption of extreme hardship solely on the ground that publication will identify a defendant who is well known, or, as I've referred to it more broadly, people who think they're well known. Victims, witnesses and others will be able to seek name suppression on grounds including that identification would result in undue hardship to that person, and importantly, clause 205 is designed to protect victims. Automatic name suppression will continue to apply to victims of specified sexual offending, defendants in cases of incest or sexual conduct with a dependent family member, and child witnesses. It will be extended to also apply to child victims. I think that goes some way to addressing Mr Nash's concerns. I think the more broad points that were raised by Mr Hipkins lend themselves to reinforcing the reason that the government has asked the Law Commission to look very closely at this issue of the relationship, broadly speaking, between suppression and new media, which makes it a lot more difficult. Now, I am not an expert in technology. I wouldn't even regard myself as an amateur. Frankly, I'm pretty relaxed about that. But as I always said, no good ever came of Facebook. But putting that to one side, this is an issue which eventually future governments are going to have to grapple with when the Law Commission brings its report back to whoever the Minister of Justice is at the time. It's not straightforward. Talking to colleagues in comparable jurisdictions, they have struggled with it. But the way suppression has interacted with the new media means there is much to do to ensure that those protections, where appropriate, are protected. And much work remains to be done in that area.